Hello folks. In this video, we're going to look at a few options you have to settle matters outside of the courts. If you're divorced and whether you have kids or not, we're going to look at a few options where if there's a dispute between you and your ex and you would really like to avoid going to court, then there are a few ways you can do that, and there are a few um, professionals that you can use to help you settle those disputes. We're going to look at four options today. The first option is mediation. Mediation is basically useful if you and your ex don't have a lot of law knowledge and don't have attorneys, and you just want somebody who's knowledgeable about the law to sit down with you and tell you how to work out your disputes from a legal perspective. In other words, this professional should be able to tell you that if you were to approach the court with this dispute, then this is how the court will reasonably rule on it. So with that knowledge, that person can then tell you what a reasonable judge would do if you take the matter to court. Using that information, you can then both of you and your ex can then decide how to resolve the disputes. So this will work if you and your ex are able to sit down and negotiate or discuss options peacefully and cooperatively. This will not work if you and your ex are just completely not willing to see each other's face, or if you're in a highly contentious relationship. So let's go with this option if you are able to negotiate with your ex cooperatively. The way it works is that you find a professional mediator, and you can find that in the directory, in your court directory, or just do a Google search, and you'll see a lot of professional mediators for family court. Of course, you have to see mediators who have expertise in family law. Once you pick one, what you do is you book some time with that mediator, and both you and your ex go to that mediator in their office and sit down, and then there's going to be back and forth discussions. You will present what you desire or you believe is right, and your ex will do the same. And then what the mediator does is the mediator says, normally courts tend to do things this way. Normally, in such disputes, there's a statute that says that this is what should be done or this is what must be done. And then using that knowledge, that mediator will then suggest solutions that maybe in a middle, maybe at a middle ground between what two of you want, or maybe it's just what you want because you're in the right when it comes to the law and your ex is not, or the other way around. Either way, the mediator will then use their experience to suggest solutions. In the end, after some back and forth, what will happen is the goal is that you and your ex will come out with a signed agreement that the matter will be resolved with an agreement, and the mediator will print the agreement out and have both of you sign the agreement. That is the goal. It might not always happen. If you have five different issues, maybe you agree on three and the other two are not in agreement. Either way, that's the goal basically, to get out to a signed agreement. It is not going to be a legally binding contract. It's just a signed agreement. And using this, as I said, if you are able to negotiate cooperatively, if you have a fairly cordial relationship with your ex, then a signed agreement is all you want, because you just wanted to approach someone who has some legal knowledge to see what is the right thing to do under the law. The mediator's qualifications, basically, there is no requirement, because it's just an agreement that's coming out. It's not a legally binding contract or anything like that. But so you can get anybody to mediate. You can get a friend or family to mediate, but then often friends and family, they're not able to be neutral, right? So they might be able to help you out of their their desire to help both of you resolve your dispute, but there's always going to be this question of whether that person is neutral or if that person is taking sides. And then many of those also don't want to get involved because they want to be with both of you. They don't want to appear to take sides in any matter that's hot, right? So you want somebody who is a neutral individual that knows neither of you, and preferably that person is an attorney or has been an attorney in your jurisdiction in family law. And when you do a search on the internet, you will find lots of such professional mediators who either are current attorneys or have been an attorney with a lot of experience in family law, or maybe they were judges. It could be anything. The other qualification needed is good negotiation skills. Basically, what will happen during this meeting with the mediator is that the mediator will present options in such a way that you understand what they're trying to say, as what a court would do. They have to have those good negotiation skills, otherwise they will not be able to get the two of you to agree on the matter, right? A good negotiator it's not about them getting what they want. Of course, all they want is that the two of you step out of their office with an agreement, because after all, that's what you're going to pay them for, right? You're going to pay them for helping you reach an agreement. So they have to have those good negotiation skills that can go back and forth between the two of you, and just enable you to achieve common ground somewhere. The expected agreement is a signed agreement. The expected outcome is a signed agreement. And if you have any concerns that your ex might go back on the agreement, then what you can do is you can take the signed agreement to court to get it recorded. It's not a complicated court procedure. It's just that, you just sort of go to court and give it to the clerk. And if both of you are there, then it's a fairly easy process. And if either of you have an attorney, or if you want to take the help of an attorney to get it recorded in the court, the attorney can take care of you, take care of getting it recorded. It doesn't have to be done, as I said. The only reason you might want to get it recorded in the court is that later on, if that dispute comes up again, your ex, if they are going to if you think they're going to turn back on the agreement, then it's better to have it registered in the court. It's like getting registered in the court as opposed to just having, signatures there with no legal person present. The mediator can only say that, yes, they signed it together in my office, but the mediator is not a judge, right? So it's not going to be legally binding. So the next option, if you want something legally binding, the next option, which is our second option in this case, is arbitration. It is very similar to mediation, but with one key difference. The key difference is that arbitration is legally binding. So the result that comes out of this arbitration process is legally binding on both of you. This is very helpful if parties cannot negotiate cooperatively. If the relationship is contentious and there is no way the two of you can sit in with a mediator and negotiate something cooperatively, then arbitration might be the other option. In this case, it is preferred. It'll work best if both of you have attorneys, or if both of you, or if one of you knows the law, the other has the attorney, but basically somebody with knowledge of the law would be very useful to have here, because what you will do is, basically the way it works is that the two parties submit pleadings to the arbitrator. You find somebody who's an arbitrator, and what you do is you book a date with that arbitrator saying, okay, well, we will submit our pleadings on these dates, and the arbitrator will then read the pleadings with all the evidence submitted and come out with a decision. Very similar to how it is done in court. The only difference is that usually in arbitration, there is no oral argument. What I mean by oral argument is that you don't go in front of the arbitrator and orally explain your case, right? It's not the way it works in court. It's very different. Usually parties will just submit their pleadings, which is basically their arguments and their evidence, in some sort of a PDF that they will email to the arbitrator, or maybe printouts that they will mail to the arbitrator or courier to the arbitrator. And then the first person who really is the petitioner for the motion will submit their pleadings to the arbitrator, and then the other person will submit a response, and then the first person will submit a rebuttal or a reply. Very similar to how it is in court, but it is not in front of a judge. You don't have to go and talk. You just do it all on your computer or on paper, and you just mail it to them. The arbitrator will read both the sides and both the arguments and look at all the evidence and then come out with a ruling. That ruling is equivalent to a ruling by a judge in a lower court, which means that you are legally bound, both of you are legally bound to obey that ruling. If you do not obey that ruling, you can be taken to court, and you can be held liable for the other party's attorney fees if it is proven that you have intentionally and in bad faith disobeyed that ruling. So you can be taken to court if you deliberately and consciously do not follow what the arbitrator has ruled. It is very different from mediation. Mediation, all you have is sign agreement. There is no legal binding, although there is going to be a binding. If you are taken in court for mediation for violating the agreement of a mediation, the court may enforce the agreement, but there is not going to be any legal penalties, most likely, if you just disobey a signed agreement, which is not a court order. In this case, for arbitration, there is going to be a legally binding ruling. The arbitrator's qualifications are very similar to those of a mediator's qualifications. Many times, mediators are also arbitrators. It just depends on which services of them you want to employ. So if you approach a mediator, the mediator might ask you, do you want mediation or do you want arbitration? Because they can do both, because the qualifications are very similar. This person, the mediator, is also most likely going to be an attorney or a former attorney with lots of experience in family law in your jurisdiction, or maybe a commissioner or a judge, because they're used to reading the pleadings and coming out with a ruling. So they might also have experience as a commissioner and a judge, and maybe they're retired and they're doing this arbitration work. The arbitrator is also court authorized to enter a ruling. Because their rulings are going to be legally binding, they have authorization from the court to enter a ruling that is going to be legally binding, right? Just anybody cannot just enter a legally bound ruling. This person is authorized by the court. They have gone through the licensing process. They have gone through proving their qualification to the court. They have gone and proven that they have the experience to come out with rulings that uphold the law and the statute. So this person is court authorized to enter a ruling. The expected outcome is a ruling. It's a legally binding ruling. Option 3. Now this is useful if you have kids, because if you don't have kids, it doesn't really make sense. So this is called co-parenting psychotherapist. This is a term used in Washington State, but in different states, it's different. Some states call it co-parenting mediator. Some states call it co-parenting moderator. But from the name, you can understand if it's a mediator or a moderator, then that's exactly how they operate. All they're doing is helping you settle disputes, but they're not making a ruling themselves. If you have kids, then, and if you have a high conflict kind of communication regarding the upbringing of the kids, then it is expected or likely that every few days, every few weeks, you will have this little dispute that it just doesn't make sense to go to court or take 3 or 4 hours of a mediator's time and pay them for that time to just settle one little tiny dispute, right? And it doesn't make sense to go to an arbitrator every few weeks, because it's just extremely expensive if you do that, and the issue will be so small that it's just not worth all that effort of submitting pleadings to an arbitrator. So if you have kids and a high conflict communication, high conflict relationship about the kids, and you have these disputes every now and then, every few days, every few weeks, what you can do is you can hire a co-parenting psychotherapist. The co-parenting psychotherapist or the co-parenting mediator, as the case may be in your state, basically works by instituting a few communication rules. For example, one communication rule that's very common is that all communication will happen only over email. There will be no phone calls, there'll be no text messages, there'll be no in-person meetings. In-person exchanges of the child are okay, but there'll be no communication except over email. And then this co-parenting psychotherapist will be CC'd on every email that each person writes to the other person. That's an agreement that the both of you will sign, and this person will be watching every email and then calling you out if you disobey any of the rules that you agreed to. Many co-parenting psychotherapists have these rules that emails may not be more than a certain number of words. One email should have only one topic. Like, don't have 5 different topics in one very long email. No, separate emails, one topic per email. In your email, you may not use insults or demeaning or curses. You may not do any of that. And he or she, the co-parenting psychotherapist, will set out these rules that the two of you will agree with and sign. And then if either of you is not following those rules, then he or she may call you out, and either privately or in an email to the other person and you, that these are the rules you broke. The intent here, the co-parenting psychotherapist's intent here is to improve communication between the two of you, right? So you can solve your own disputes if you have better communication. While they're doing that, it's called therapy. Basically, they're co-parenting psychotherapists, right? So it's basically like therapy for the two of you to enable you to communicate better. And while you're learning that, while you're in that kind of therapy using email, the psychotherapist will also actively negotiate ongoing disputes. While you're still working on improving communications, the psychotherapist will also actively negotiate ongoing disputes. And the reason they can do that is because of their qualifications, right? So if you go to the psychotherapist qualifications, one is that they have a psychology degree. I mean, they will be a professional in psychology. So they might have a PhD, they might be a practicing psychotherapist in general, for parenting as well as non-parenting. But they have this understanding of human psychology, and they have this understanding of parenting. So that's one qualification. And the other qualification they have is they have some legal knowledge as well. So if they know your parenting plan and you say, hey, I want to do this, and your ex says, I want to do something else, then they'll be able to look at your parenting plan and then tell each of you that, hey, I have this legal knowledge, I know what this clause in the parenting plan means, so why don't we try to negotiate with each other cordially and cooperatively to settle this one little dispute per the parenting plan, right? So it's that person has a unique set of qualifications where they know psychology and they know the law, and together they can be very effective if they can participate in all conversations between the two of you. The goal here, the expected outcome, is that there's going to be ongoing dispute resolution, right? So as long as you have that person in CC in that email and they're watching all the disputes you're having, then they'll be able to help with ongoing dispute resolution, right? If it happens every few days, every few weeks, they're there, ongoing dispute resolution. So you don't have to go to court or go to arbitration or go to mediation every time. Many times that person is the co-parenting psychotherapist is just not able to get the two of you to agree on a dispute. In that case, what they usually do is they refer the matter to arbitration. So they declare an impasse, that they say that I just tried my best and I just cannot get the parties to agree, then you may go to arbitration. So they will not come out with a ruling. They are not authorized to do that, but they can suggest that this matter should be taken up to arbitration. So that's the expected outcome. ongoing dispute resolution. And if they're unable to on a certain issue, they call it an impasse and they refer it to arbitration. Many times they will say that if you guys don't agree and if you still don't even want to go to arbitration, then I'm going to resign from my position, right? I mean, they use this kind of negotiation, which is, I mean, the goal is to enable you to either agree or go to arbitration rather than keeping on dragging on with that issue and keeping on communicating over it again and again. Their goal is to either close this matter now by agreeing to something, right? Or just giving up, saying, okay, we agree to disagree and forget about it, or take the matter to arbitration, but basically close the matter, right? The fourth option is also helpful if you have kids. It can still be done, you can still extend it to if you don't have kids, but again, it's very much like the co-parenting psychotherapist, where the case manager enables you to resolve ongoing daily or weekly disputes. The case manager is not like an arbitrator in that you submit pleadings about a big issue. No. The case manager is very much like the co-parenting psychotherapist in that they are there, always there to be contacted for little ongoing disputes. And they're particularly helpful if this is a high conflict communication case. You and your ex are unable to communicate cordially and just not able to, settle any disputes. And you don't want to keep rushing to an arbitrator. You just say, well, have the case manager look at everything right then and there and solve this little matter right here. And basically this case manager, what the case manager does is, they engage immediately with the parties whenever there's an dispute. There's ongoing dispute resolution as the case may be, and you may email the case manager, make your argument over email, and they may look at the parenting plan, they may look at your court orders, and then decide, okay, this is the right thing to do. And the case manager has the authority to rule on the dispute. So it's in this case is different from the co-parenting psychotherapist. The case manager, you will sign an agreement with the case manager, or a court will order a case manager saying that in case of disputes, the case manager is authorized to enter a ruling which becomes legally binding. Okay, so in little things, the case manager will say, well, I believe that the parenting plan says that the child must be dropped off by 6 p.m. at this location, right? So they will enter a ruling saying, hey, dad, or hey, mom, you must go drop the child off at this location by 6 p.m. and that becomes legally binding. When I say legally binding, it's not a court order. It's not that you'll be held in contempt for disobeying, but what happens is if you disobey what the case manager has ruled on, then your ex might take you to court and file a motion to enforce, saying that the case manager is making this ruling or has made this ruling and you are not obeying it. The court will very likely just enforce the ruling that the case manager has made because that's their job. The case manager was employed or hired to make rulings, right? So although it's not like a violation of a court order because a case manager is not a judge, but it has a very high likelihood of the court enforcing what the case manager is saying. I'm just saying likelihood. Sometimes case managers can be wrong, but it's a very high likelihood. You'll have a battle to win, right? And it'll be a high bar to prove to the judge or the commissioner that you have a valid reason to not follow the case manager's ruling, right? Because you agreed to it, or sometimes the court orders a case manager. In that case, you just have to obey the ruling because then if you don't obey the ruling, then you're essentially violating the court order that instituted that in the first place. The case manager's qualifications are also going to be attorney or former attorney because they have to know how to read the parenting plan. They have to know how to make rulings. They have to know how the system works. Some psychology will be helpful, especially if there are kids involved, because there's going to be disputes about parenting. So some psychology knowledge will be very helpful, and they should be available to participate in ongoing disputes. So you should be able to just email them saying, hey, this is a matter that needs to be resolved by the end of the week because I have to pick my kid up on Friday. So it's Tuesday, can we get a resolution, by Thursday so I can know when to pick my kid up, right? So they're always available for these little disputes. There should be, that's the qualification, they have to be available. And the expected outcome is ongoing dispute resolution, which is legally binding. And I said legally binding with a caveat, as I explained, but very different from the co-parenting psychotherapist, who cannot come out with any kind of legally binding ruling, but the case manager is authorized to do that. So these were 4 options to stay out of court. There is always the option, there's always the possibility of challenging any of the legally binding rulings. So case manager's ruling or the arbitrator's ruling, just like any ruling by any court, you can always take it up with the next higher court and challenge that ruling, except for the US Supreme Court of Appeals, which is the final authority, right? In arbitrator's ruling, there's a specific procedure there's a statute, and it'll also be in the arbitrator's ruling that if you want to challenge the ruling, then here's the procedure. You have 20 days to do this, and this is how you do it. And then you take it up to a commissioner or a judge, and then explain to them why the arbitrator made a mistake. Usually, your chances of winning at such a challenge are low because it is likely that a different person who is trained in the same law as the arbitrator, who has read the same statutes and who has a similar experience, is very unlikely that that other person will rule differently in your case for the same arguments and for the same evidence. It's very unlikely they will rule differently, but it's very likely they will make the same ruling. And so as you challenge court order, as you challenge any kind of legally binding order, it just has to meet a very high bar for you to win that, right? So let's recap quickly. Basically, if you have a lot of little disputes on an ongoing basis, and if you have kids, then co-parenting psychotherapist or case manager are 2 good options. If you don't have kids, it's just unlikely that you'll have ongoing disputes, right? Because kids, parenting, drop-off schedules, visitations, vacations, expenses, these are the kinds of things that parents usually have disputes over when they're divorced. If you don't have kids, it's not expected to have ongoing disputes, but in any case, it is more useful if you have kids, if you want to use co-parenting psychotherapist or case manager, one of them being legally binding, the other one not being legally binding. If it's once in a while disputes which are worthy of spending, a few $1,000s with, by going to a mediator or an arbitrator who charge hundreds of dollars an hour, then that's the way, mediator or arbitrator, again, with one of them being legally binding and the other one not being legally binding. So these are the 4 options. There are many other variations of options as well. And as I said, these terms I've used here are mostly true in most states, but some states use slightly different terms. But whatever terms they use, these kinds of professionals, so a professional who does mediation, no matter what they're called, a legally non-binding mediation will be available. And then another professional who does legally binding, whether it's called arbitrator or called something else. Some states, they call it administrator, or whatever that thing is. The concept is the same. I hope this was useful. If it was, please like this video, because then I will know it's useful so I can produce more videos like that. And if you want to see my other videos, and if you want to be notified, please subscribe to my channel and share this video if you're interested in helping others that you know understand this part. Maybe you can share this video with your ex. Tell them that, you know, these are the various options, and if you have a cordial relationship with them, maybe you can choose mediation or co-parenting psychotherapist. You know, if it's not really that cordial, but still you want ongoing help. I wish you the best. Thank you for watching.